Hello everyone and welcome back to my channel. Today I want to talk about adjustment of status under section 245I of the INA, the Immigration and Nationality Act. Before I dive into this topic, if you have any questions, please drop a comment below. Otherwise, if you want to set up a consultation, visit us at our website, carboneattorneys.com. We have a button in the top right corner of our website. Click it, fill it out, and we'll get back to you as soon as possible. So for anyone seeking a green card in the United States, there's two paths. So there's adjustment of status, which is the most preferable path because you get to process everything while in the United States. Whereas the other side is consular processing, where you start the process in the United States and then the remainder of the green card process takes place at the non-citizen's country abroad at the local embassy or consulate. So of course, adjustment of status is obviously the most ideal path. However, not everyone is eligible. So if you have overstayed a visa, if you've entered the US not at a port of entry, so if you've come any other way besides at a border point or an airport, you're not eligible for adjustment of status. Also, if you've ever worked without authorization, again, you're not eligible for adjustment of status. Now, the caveat there is that if you are an immediate relative of a US citizen, meaning you're the spouse, parent, or child under the age of 21, these things don't apply to you and you actually can adjust status. Now, for everyone else, for everyone that may be eligible for a green card, but they're not considered an immediate relative, you would have to go through consular processing if any of these factors apply. Overstaying your visa, entering at at a point that's not at a border or airport, and so on. What makes Section 245I interesting is that through this section, you actually can be eligible for adjustment even though you would otherwise be disqualified. So back in 1994, Congress passed some laws that allowed for individuals who would not otherwise qualify for adjustment to qualify. And this law was renewed until the last time, which was around, I think, December, I don't remember the specific date, but sometime in December of 2000. Now, what that last bill did, what that last law did, is it created a cutoff date. And that cutoff date is April 30th, 2001. Why is this date important? So if you have a petition that was filed on your behalf, meaning you were the principal beneficiary or derivative beneficiary, you're the spouse or child under 21 of the principal, you may be eligible under 245I. So this petition needs to either be a family-based or employment-based petition or a labor certification, and it needs to be filed on your behalf on or before April 30th, 2001. It's a very important date. If anything was filed after that, we're not talking about 245I. This is a completely different conversation altogether. So another important factor here is that the petition that was filed on your behalf must have been approvable when it was filed. Now, what this typically means is that obviously it wasn't filed for a fraudulent purpose. The filing fees were paid, all of the forms were filled out and signed, and the necessary evidence was submitted in support of the original petition. So a common example is an application submitted on your behalf before April 30th, 2001. It gets rejected because there's no filing fee or the application wasn't signed, and then the application is refiled after April 30th, 2001, and now you've lost the protection of 245I. So because this deadline, this April 30th, 2001 deadline is over 20 years ago, some people that had an original petition filed on their behalf are now no longer eligible. So let's say you were a spouse and now you're divorced, or you were a child of the principal beneficiary, but now you're well over 21 years old, you've aged out. Fortunately, under 245I, that original petition, although no longer valid, can still be used as evidence in support of a newly filed petition. So let's say you are a relative of a US citizen or a legal permanent resident, and a petition was filed on your behalf, but your visa overstay, or you worked without authorization. Of course, you're not eligible for adjustment, but that old petition can actually be used as evidence that you should be eligible for adjustment under Section 245I. So even though you may no longer qualify under the old petition, but you qualify under a new petition, you can use that old petition from over 20 years ago to act as the evidence that the government should recognize your eligibility for adjustment of status. Now, obviously, you still need to hit all of the other eligibility requirements for adjustment, but now you're protected from having to go through consular processing. So ultimately, adjustment of status under Section 245I is really a protective measure for individuals that have petitions filed over 20 years ago, and now they have the ability to adjust status and, continue living their life and not have to worry about leaving the country. So I will drop the full eligibility requirements in the description below, but that's it. That is adjustment of status under Section 245I. I hope you enjoyed this video. If you would like to see more of these, please like, subscribe, and I will keep making them.